Welcome, everybody. My name is Jonathan Kahn. I'm a professor of law and biology here at the Northeastern University School of Law, and I'm welcoming you all to this event co-sponsored by the Center for Health Policy and Law and the Center for Law Innovation and Creativity here at the law school. I am really delighted to be able to welcome Jorge Contreras to give this talk about his book, The Genome Defense, and this about his book, the Genome Defense Inside the Epic Battle to Determine Who Owns Your DNA. George is the James T. Jensen Endowed Professor for Transactional Law and the director of the program on intellectual property and technology law at the University of Utah. He teaches and researches in the areas of intellectual property law, technical standardization, antitrust, and science policy. In 2020, he received University of Utah's Distinguished Research Award and is an elected member of the American Law Institute. So what we'll be hearing about today is this book, The Genome Defense. And I just want to say I've known George for really quite a long while now. And it's just such a pleasure to see this book come out, because it's, for those of you who haven't had the opportunity or pleasure of reading it yet, it is incredibly readable, engaging, fascinating story about the Myriad case and the actors behind it. And also just has all sorts of broader implications for our understandings of the place of patent law in the realm of biotechnology and beyond. So without further ado, I think we're all in for a treat, and I'm just going to turn it right over to George and look forward to this talk.
Great. Well, Jonathan, thank you so much. Thanks for the invitation to you and to Northeastern and to a lot of friends and colleagues that I see here on the line. So it's a real pleasure to be here with you. So with that, let me see if I can accomplish this sharing here. So as Jonathan mentioned, I'm going to talk about this case and this book. If you've taken patent law or know anything about patents, you've probably heard of the case, which is a pretty famous one from almost 10 years ago now at the Supreme Court level. And it was a challenge led by the ACLU and the Public Patent Foundation against patents held by a company called Myriad Genetics. And the patents claimed two human genes, BRCA1 and 2, which are closely associated with breast and ovarian cancer. Right. And so this was a big case. It went to the Supreme Court. It clearly had a big impact on patent law and subject matter eligibility. But the reason that I was interested in it and the reason I wrote a whole book about it is not because of this, but because it had a lot to say about a lot of other issues and brought a bunch of things to light around access to health, innovation, how the government makes policy in these areas, sort of philosophical questions about commoditization of individuals, of peoples, our knowledge of ourselves through our DNA, and a lot of other stuff. So, quick review for those of you who have patent law, right? A patent is a right conferred by the government, and the holder of that patent gets 20 years during which they are the only ones in the United States that are allowed to make, use, or sell whatever the particular patented invention is. Okay, so 20 years from the date you file your patent application, it's a pretty long time. This is a very powerful right. You can get a patent on what's called any new and useful invention, right? This is what Section 101 of the Patent Act says. And so we're familiar with things like apparatuses and machines. We build a better mousetrap, you can get a patent on it. We also issue patents on processes, chemical manufacturing, all sorts of other processes and methods. Things that are manufactured can get patented, and most important for today's discussion, compositions of matter, new substances that are created in the laboratory, in the factory, things like rayon, polyester, new metallic alloys, carbon, graphite, fiber, all of those new materials can be patented. And one of these composition of matter patents is extremely powerful, Because if you invent a new material, say you were the inventor of polyester or PVC, then you have the exclusive right in the United States to every possible use of that thing, right? So whether you make drinking water bottles out of it, or insulation, or food trays, or clothing, all of those uses are controlled by whoever owns the patent on this new material. Kind of makes sense. Now, an exception to this rule is that you can't get a patent on what's called a product of nature. So something that you go out into the forest and find, you can't patent it. You basically didn't invent it. So you're an explorer, you go into the jungle, you find a new fungus. It seems to heal your burn on your arm very well. That's great. You can't patent the fungus because you found it in nature. You might be able to create some kind of a burn ointment out of it, and that you could patent, right? But even if you find the fungus, you discover it, it's useful, and then you purify it in some way to get all the dirt and the sticks and twigs out of it from the forest floor, you still can't patent it just because you purified it, right? In order to get a patent, the thing has to be markedly different from the thing that occurs in nature. And as you can imagine, we've had a lot of litigation and court cases about that. A landmark case that came out in 1980 involved a modified living bacterium, which scientists inserted a plasmid into that made this bacterium more eager to decompose hydrocarbons, oil spills, effectively. That was patentable because the modified bacterium was different than the one that you go out and find in nature. All right, so those are the ground rules. Now, let's think about human genes. So as you probably all know, we each have about 20,000 genes in our bodies, in the nuclei of every one of our cells. They sit there on 23 chromosomes. In the human body, of course, you can't patent those chromosomes or the genes. They exist in nature, they're created by nature, you can't patent them. But what if you took a chromosome and spliced out of it one individual gene? You broke it out. And remember, on the chromosome, you can't really tell where one gene begins, where it ends. It's all undifferentiated nucleotide sequence. You figure out where the gene is, and you splice it out, and now you have it in the laboratory. You amplify it millions of times so that you can study it and do stuff with it. That isolated gene did not exist in nature. When it was in your body, it was attached to the big chromosome that has thousands of other genes on it. In the laboratory, it's isolated, purified. That thing doesn't occur in nature. And so the patent office, beginning in the late 1980s, adopted this policy that if you isolate a gene like this and you have some inkling of what it does, then you can get a patent on it, right? So you can patent that new isolated gene as a composition of matter, just like your new metallic alloy or synthetic fiber. And this led to what many have called the gold rush of gene patenting. As gene sequencing equipment got better from the late 80s through the 90s to the early 2000s, researchers were discovering more and more genes that had relationships to particular diseases or physical characteristics. So when researchers at University of Michigan discovered a gene closely related to cystic fibrosis, they patented it. Same thing with many others, so that by 2005, a couple of researchers at MIT estimated that fully 20% of human genes were covered by some sort of patent protection. Okay, well, this bothered many people. And a number of people tried to challenge the patents that were being issued on these genes. One of them is a law professor, Lori Andrews, at the Illinois Institute of Technology, who brought litigation against Miami Children's Hospital, the owner of a gene that is closely associated with a pediatric disorder called Canavan's disease. The challenge was unsuccessful. She was a law professor working out of a law school clinic with some students and volunteers, completely unable to match the legal litigation firepower of a major research institution. And so this case didn't really go anywhere. There are other challenges being made to patents in the biotech sector around this time. Also, this is the early 2000s. One person who did this was Dan Ravischer, who was a patent lawyer at a big New York firm, but left to form what he called the Public Patent Foundation. They went around looking for what's called prior art to challenge existing patents. And so he found, and his group found, some existing discoveries and disclosures that read on Pfizer's patent covering Lipitor, which at the time was the best-selling drug of all time, a blockbuster multi-billion-dollar drug, and actually at the patent office instituted a procedure to get this Lipitor patent invalidated. Now, that was just one patent and one substance, not all of them, but still very effective, and he got a lot of publicity as a result of this. But what if you wanted to challenge not just one patent on one drug, but all patents on all human genes? This is what started to brew at the American Civil Liberties Union in about 2005. In 2003, the ACLU hired its first science advisor, a person named Tanya Simoncelli, who was out at Berkeley, California at the time, working at a nonprofit around genetics policy, mostly looking at things like DNA identification, police use of DNA databases, collection of DNA information from individuals. Nevertheless, she was hired by the ACLU, and her role was to alert the ACLU litigators of potential cases that they could bring that implicated both civil rights and scientific issues. And so she raised with Chris Hansen, who was a very senior litigator, 30-year veteran at the ACLU, this issue of gene patenting. And honestly, he didn't believe her at first. He could not believe that companies were able to get patents on human genes that were basically unmodified from their status in the body, save for being separated out from the rest of the chromosome. And he and she put their heads together and tried to figure out how you could challenge these patents covering human genes as a civil rights issue, because this is, of course, what the ACLU does. The first thing to do, though, when thinking about this, is to figure out, if you're going to bring a civil rights suit, who your defendant is. And by this time, there were hundreds, if not thousands, of patents covering different human genes. And so, as a litigator, you've got to find your defendant. And as the ACLU, bringing a civil rights case, you've got to find a defendant who is going to, you're going to be able to tell a story that's a sympathetic story to the public, to juries, and to courts. And so here's a gene, LQT, various LQT genes that exist in the body, first isolated and discovered by the University of Utah, and licensed to a company called PGX Health. So what is the LQT gene? It's closely associated with a disorder called long QT syndrome, which is an irregularity in the heartbeat, right? It's a cardiac arrhythmia, often pediatric. It occurs in infants, children, and it's often fatal. You have this disorder in your heartbeat, causes your heart to misfire, and you can really suffer sudden death. And this was happening. If you administer beta blockers to a person with this genetic defect, that will avoid long QT syndrome. But you don't want to administer beta blocker drugs to everybody. So you want to do a genetic screening test to find out which babies have this disorder so that you can administer this drug to them. In order to do that, you have to run a diagnostic test. In order to run that diagnostic test on this gene, you need rights from the owner of the patent on that gene. And if you remember from the last slide, oops, it's a beta blocker. If you remember from the last slide, this company called PGX Health owned that, or was the exclusive licensee of that patent. The problem here is that PGX Health went bankrupt. And in bankruptcy, the trustee in bankruptcy would not allow anybody else for years to run any tests utilizing that patented gene. The trustee's job was to auction off the patents to maximize the value to the estate. So for 2 years, nobody was able to run this test, and you, very unfortunately, had children and infants dying because they weren't identified as having this genetic defect to administer the drug to them. And there were a number of people who were on the ACLU team who thought, this is the gene, this is the patent that we ought to challenge. You've got babies dying. That is very serious. And it is, and it's tragic. But the leadership at the ACLU, Chris Hansen and the executive director of the ACLU decided, no, we can't bring the suit based on long QT syndrome. Why not? Because other than the families who were tragically affected by it, no one had really heard of it. What we need to do is find a disease that affects more people, and they did. Breast cancer, of course. Breast cancer is one of the most highly advocated for diseases in the United States, raises more funding than anybody else. It's huge, and pretty much everybody in the United States has been affected personally in some way by breast cancer, either because they have it or because a close family member, a friend, or a colleague has had it. And so it really hits home with a lot of people. And so who owned the patents covering the breast cancer genes, BRCA1 and 2? Well, it's a company called Myriad Genetics, based in Salt Lake City, Utah. So what's the story of these BRCA genes? So by the 80s, well, let me take a step back. For a century, doctors knew that breast cancer ran in some families. In about 5% of breast cancer cases, there was a clear familial tie. Some families were cursed with a lot of these cancers. So they knew there had to be some genetic link. It wasn't until the 80s that gene sequencing technology had evolved to a state where we could plausibly try to find those genes associated with breast cancer. And in 1990, a landmark was reached. A researcher named Mary Claire King out at Berkeley, through genetic epidemiology techniques, kind of roughly located this gene. She proved mathematically that it must exist. And if it exists, it must be somewhere on the long arm of chromosome 17. Remember, we've got 23 chromosomes. They've each got 2 arms. So we've now narrowed down the location of this gene quite a bit, but not enough, right? There are going to be millions of DNA bases along this segment of the chromosome. The gene is not that big. It's going to take a lot of extra work to find it. And her discovery kicked off an international race among a dozen research groups around the world to find this gene. So in 1991, Mark Skolnick, who's the guy is pictured on the right-hand side of the slide, he's a researcher at the University of Utah. He teams up with Wally Gilbert from Harvard, who's a Nobel laureate, the founder of the biotech company Biogen, so extremely well-known in the field, and a venture capitalist named Pete Meldrum here in Salt Lake City. They found a company for the specific purpose of searching for the BRCA gene. They are competing with research teams from University of Michigan, Toronto, Japan, Germany, all over the place, but they have some advantages. Number one, they raise a lot of money, both from venture capitalists and investors, but also from the pharmaceutical industry. Eli Lilly invests a few $1 million. They get money from the National Institutes of Health. In addition, the University of Utah grants them exclusive rights to all discoveries relating to the BRCA genes that are made at the university, at Mark Skolnick's lab at the University of Utah. So this company has a pretty big advantage in searching for this gene. And to cut right to the chase, they win this international race to find the gene in 1994. So it took 4 years to find and sequence this gene. And immediately after they find it, they file a patent application. All right. Patent takes about 3.5 years to issue. We'll get to that in a minute. But what happens once they find this gene? So being good scientists, and again, remember, many of the researchers are still at the university, they're academic scientists, So they published the sequence of the BRCA1 gene, which, by the way, is so closely related to breast cancer. If you're a woman who has one of 3 particularly deleterious mutations in this gene, your lifetime risk of getting breast cancer is 8 to 10 times the normal population risk. This means that you have something like an 80% chance of getting breast cancer during your lifetime. That's a very high risk. So universities and clinics start to screen patients for these mutations. By 96, University of Pennsylvania is screening about 500 patients every year. Why do this screening? Well, because if you have one of these mutations and it's found in a genetic test, then you can take prophylactic measures. For example, you can have a prophylactic mastectomy, a surgery to remove the breast tissue that's likely to develop cancer. The same thing with BRCA2, which closely relates to ovarian cancer. Myriad is also starting to offer this screening test as its own business. In 1997, that first patent issues on the BRCA1 gene. And when that happens, Myriad starts to shut down the other clinics and laboratories in the United States that are using this gene to run this screening testing, right? So in 1998, it sues University of Pennsylvania. They stopped testing other university clinics around the country, same thing, Georgetown, Yale, so that by 2001, Myriad is the only provider of BRCA1 and 2 screening in the United States. All right, well, so what? That's just how patents work, right? So there are a number of complaints made about Myriad and how it proceeded. The first thing is that it priced its test at a pretty high price point, a test that, was estimated probably cost it $200 to run. It's charging over $3,000 for. And what's wrong with that? Well, certainly in the early days, it was not covered by most insurance policies. It was not covered by Medicaid or Medicare, the big federal programs, who just were not willing to pay that much for a diagnostic test. Remember, that's administered to people who are healthy, who do not have cancer yet. Even if you have one of these deleterious mutations, you may not develop cancer for 20 years. And insurance companies generally aren't that fond of paying a lot of money for a test on a healthy person for disease that they might not get for another couple of decades. As a result, the test is unaffordable to many patients who may have had a strong family history, strong clues that they might have had one of these mutations, but you're not going to get a radical prophylactic surgery on just the chance that you might have one of these mutations. So this was problematic. Second, even if a patient did get Myriad's test and had a positive result, they could not get a second opinion from another laboratory. There was no laboratory to do confirmatory testing. And if you're facing a serious surgical procedure, you often want a second opinion. That was not possible in this environment. Another problem that was pointed out is that once Myriad had a monopoly on this testing, its incentive to improve the testing was very small, right? And so researchers in the academic laboratories were finding other types of mutations that were not covered by Myriad's test, and Myriad was the only one who was authorized to perform the test. And those academic researchers who were finding other variants weren't allowed to tell their research subjects that they found such mutations. Overall, there are researchers who found that the patents, both on BRCA and other patented genes, were chilling research into those genes. And as science advanced through the 1990s and early 2000s, these patents were interfering with companies who were starting to produce multi-gene panels, multiplex testing, because you can't test sort of for defects in all of your genes if some of them are patented, right? These tests were sort of the Swiss cheese effect. There were holes all throughout the genome that couldn't be touched because of these patents. So what did this mean? This was a situation in which Myriad was getting a lot of criticism. The fact that the ACLU focused on breast cancer, on the BRCA genes, also converted this case from a patent case into a women's rights case. And this was important for getting support within the ACLU, the Women's Rights Project, the ACLU. Footnote, created by Justice Ruth Bader Ginsburg, who started her legal career at the ACLU, was a very powerful group within the ACLU. And they teamed up with Chris Hansen and Tanya Simoncelli to sort of formulate this lawsuit. So as a civil rights case, as civil rights lawyers, they couldn't bring the case in their own name, right? Basic civil procedure. To be a plaintiff in a lawsuit, you need to be injured by whatever the harm is it's being attacked. So the ACLU is very good at forming coalitions of plaintiffs. And in this case, they formed a coalition of 20 plaintiffs, ranging from medical associations of physicians and geneticists who are not able to run this testing, to Breast Cancer Action, an advocacy organization, to genetic counselors who couldn't talk about other tests with their patients, researchers who weren't able to perform testing, and most importantly, 6 individual women who had high eligibility for this testing. They had a strong family history of breast or ovarian cancer, could not afford the tests, or did not meet Myriad's eligibility requirements to get the testing. So those were the plaintiffs in this case. Another thing the ACLU was very good at doing was harnessing the media to their cause. And 60 Minutes, which at the time, right, was sort of the most widely watched news show in America. They were on the Today Show, New York Times. They got a huge amount of press coverage in support of their cause and the case. And so remember, this started in 2005. It took them 4 years to build this case and to decide that they wanted to bring it. They did that, and they filed suit in district court in the Southern District of New York in the spring of 2009. Myriad, the company, was completely flabbergasted by this case. They could not understand at first what was even being alleged. Was this a competitor who said they were infringing their patents? Like, no one could really even conceive that this civil rights organization was bringing a lawsuit against them to challenge the validity of all of their patents. That was unheard of. So Myriad immediately hired the largest and most powerful law firm that they could find, Jones Day. For those of you who like nonfiction legal literature, there's a new book just out this year about the firm Jones Day. But the guy on the right is Greg Castaneas, a prominent patent appellate litigator, had been to the Supreme Court, been to the Federal Circuit many times. He was the leader of the defense team for Myriad. So Myriad didn't just have Jones Day on their side. They also had the patent law blogosphere. And for those of you who study patent law or involved in patent law, you will know, and others will be surprised to learn, that the patent law blogosphere is pretty wild and woolly. And there's a lot of very opinionated people and blogs out there. And they were also shocked by this lawsuit when it was brought. A lot of calls for the ACLU lawyers to be disbarred, sanctioned under Rule 11, and have the case just thrown out because it was so absurd. And think about their perspective. By 2009, when this case was brought, the Patent Office had been issuing patents on human genes for a quarter of a century, right? 25 years of history here, an entire generation. And this was what was viewed as well-established law. It was settled law. And the fact that somebody had the temerity to challenge it was just mind-blowing to people who were in the field. So, Southern District of New York, this is the first port of call for this case. This is Judge Robert Sweet, who was randomly assigned the case. At the time he's assigned the case, he's 88 years old, and he is best known as the judge who threw out the obesity lawsuit that was brought against McDonald's Corporation by a group of plaintiffs who claimed that McDonald's food caused their obesity. So he wasn't a scientist, but he certainly enjoyed and knew something about cases involving science. However, his secret weapon was his law clerk. So for those students out there who are considering applying for judicial clerkships after you get your JD or at some point early in your career, law clerks can be extremely influential. This guy, Herman Yu, he graduated from NYU Law School, was practicing law for about a year when he became Judge Sweet's law clerk. The interesting and entirely coincidental thing about Herman Yu was that he also had a PhD in molecular virology. And not only that, he had a patent that he and his wife were co-inventors on back from their graduate school days. So he knew about patents and he knew about genetics. And so between Judge Sweet and his clerk, they came up with a theory about this case. And here was their theory. DNA exists to carry information, right? Or that's one of its primary functions in the body. It codes proteins that do things in the body. The BRCA genes code proteins that are tumor suppressors. And when those proteins, those tumor suppressors, are not coded correctly, i.e., when the DNA that codes them is broken in some way, then that person has fewer tumor suppressors and tumors grow more rapidly. And this is why we understand today the BRCA genes are so important and related to these cancers. So it's the DNA sequence of nucleotides, the A's, C's, T's, and G's, right, that form your DNA chains that are important. And the sequence of A's, C's, G's, and T's is the same whether the gene is sitting in the nucleus of your cell attached to a big chromosome or whether it's isolated and purified in the laboratory, right? So Judge Sweet rules that if DNA is an information carrier, then all of these chemical structural differences between the gene outside of the body and inside of the body, they're irrelevant. It's the same gene or the same information is being conveyed. If the information content is identical, it occurs in nature. Therefore, under the product of nature rule, there should be no patent. You should not be able to patent it. It is not eligible subject matter for patents under Section 101 of the Patent Act. Okay, so ACLU and PubPat Foundation win this round of the litigation, but myriad appeals, of course. And as you probably know from civil procedure, the exclusive court for appeals of patent cases in the United States is the U.S. Court of Appeals for the Federal Circuit, which sits in Washington. And because they hear all of the patent appeals, they have earned the nickname the Patent Court. They like patent cases, and many of the judges like patents. So at this point, something very interesting happens. At the Federal Circuit appeals level, the United States government gets involved. So you remember, the Patent Office issues these patents, but the Patent Office, for procedural reasons, was kicked out of the case very early at the district court, right? The patents were owned by Myriad. You can't challenge the Patent Office sort of on these claims. Nevertheless, the Patent Office, and this guy in the upper right, David Kapos, who was a director of the Patent Office at the time, thought that there was nothing wrong with these patents. In fact, again, the Patent Office had been issuing these patents for 25 years. This was good policy based on solid precedent. So the government should defend these patents. And the government often intervenes in cases where a government agency is involved, even if the agency is not a party to the case. And the person who makes that call as to whether the government will intervene or not is the Solicitor General of the United States. That's the guy in the lower left here, who here is talking to Stephen Colbert. So Neil Katyal became Solicitor General kind of unexpectedly when Elena Kagan, who was the Solicitor General at the time, was promoted to the Supreme Court. So Neil Katyal and his office, the Office of Solicitor General, was left with the task of deciding whether or not and how the government should intervene in this case. Should the government step in and basically make the patent office's argument that these were good patents, following long-standing precedent, there's nothing wrong with these patents. That's usually what happens in a patent case where the administration intervenes. This case was different. Here, you had agencies within the administration strongly arguing that the government should not support these patents. And the principal leader of that gang was the guy on the upper left, Francis Collins, the director of the National Institutes of Health, an illustrious geneticist in the United States. He was the leader of the Human Genome Project. He was also the principal investigator at University of Michigan, the group that discovered the CFTR gene associated with cystic fibrosis, and the leader of the University of Michigan team that teamed up with Mary Claire King at Berkeley to find the BRCA genes, right? They lost that race to Myriad, but now Francis Collins reappears on the scene decades later to have his say and his view and the view of many others in the administration at the Office of Management and Budget, the Office of Science and Technology Policy, the National Economics Council, the Antitrust Division of the Department of Justice. All of these agencies felt that you should not be patenting these genes. And so within the administration, within the government, there was a big battle going on over which side the Solicitor General would take. And eventually, he decided, as often happens, to make a compromise. And here was the compromise. In the gene, in, say, the BRCA1 gene, the BRCA1 gene is about 80,000 bases long, right? 80,000 A's, G's, T's, and C's, all strung together. But only about 6,000 of those bases, the ones that are green here in this diagram, actually code the BRCA proteins. The other bases, may have various functions. We don't even know all of the functions that they may have today, but they don't code proteins. And so the idea, it's the orangish, pinkish ones that are the coding regions of the gene called exons. When they're all strung together like that, that's what the Solicitor General called genomic DNA should not be patentable because it occurs in nature in exactly that sequence. Judge Sweet's theory. However, if you took out only the coding regions of the gene, those 6,000 bases that code the protein, and strung them together in what's called a cDNA construct, well then, those don't exist in nature. Maybe those should be patentable. So this is a compromise. Naturally occurring sequence, not patentable, but if you make something different just with the coding region of the gene, that should be patentable. What did the Federal Circuit think about this argument, which was presented by the Solicitor General? Well, here's the chief judge who wrote the opinion of the three-judge panel on the Federal Circuit, Judge Alan Lurie, who comes to the court with a PhD in chemistry, had worked at a large pharmaceutical company before joining the court. His view was this: A's, T's, G's, and C's, this theory that the district court had about information carriers, you know what? That is not what genes actually look like. In fact, this is what genes look like. They are chemical molecules. And when you take a chemical molecule like chromosome 17 and break it in two places at either end of the BRCA gene, and the gene comes out of the chromosome, you have just formed a different chemical molecule, right? You've broken covalent bonds, if you remember your high school chemistry, and breaking covalent bonds is a big deal to a chemist. Therefore, different molecule can be patented. It is markedly different from the one that occurs in nature. So the Federal Circuit upholds the patents, reverses the district court. So what's next? Of course, we go to the Supreme Court and we get there twice. Complicated procedural stuff that I won't go into here. But this is where the ACLU really ramps up the public engagement. Remember, Breast Cancer Action is one of the plaintiffs in the case. They staged demonstrations, rallies on the Supreme Court steps. People are camped out overnight to hear the oral arguments. Amazingly, superstar actress Angelina Jolie, while the Supreme Court is considering this case, publishes an op-ed in the New York Times disclosing that she had a deleterious BRCA mutation, and as a result had a prophylactic double mastectomy that she was recovering from. This was an earth-shattering story, made all of the news media, and have not affected the Supreme Court justices as they were considering this case. And so, June of 2013, this is Don Verrilli. He succeeded as Solicitor General to Neil Katyal, and Justice Clarence Thomas wrote the unanimous decision of the court, basically handing the victory to the Solicitor General and his compromise that DNA sequences as they're found in the body are not patentable because of products of nature. But if you construct a complementary DNA construct made just of the coding regions that might be patentable, this doesn't help Myriad because in the diagnostics industry, you don't do this. However, some companies may have been made happy by this. The important thing about this case is that the holding doesn't just apply to Myriad. As remember, PubPat's challenges to the Lipitor patent, they only affected one patent of Pfizer's. This decision affected every patent covering every gene across the United States. And it had an immediate impact, right? Immediately, literally the day after this decision was handed down, competing laboratories started to offer BRCA testing at half the price. Today, 23andMe, any of the personal direct-to-consumer genetics testing companies will give you this information for $100, $125, whatever it costs. And that applies not just to BRCA, but again, to every gene in the body. This case also had an impact on non-human genomic sequences, not discussed in the case, but clearly relevant. And if you think back to viral outbreaks, which are a lot on our minds these days, right? Remember SARS, MERS, H5N1, and all of those cases, those viral sequences were patented as soon as they were discovered. Those patents caused delays in research, disputes. There were news articles, scientists pointing the fingers at one another. That did not happen in 2019, 2020 with SARS-CoV-2, the virus that causes COVID-19 or all of its variants. Whoops. And we did not experience the same delays. In fact, research happened collaboratively on a global scale at an unprecedented rate, and we got vaccines. Say what you will about the distribution and the equity of those vaccines, which has been problematic. At least the research to create the vaccines happened very rapidly. Okay, I think this is a good result of the case. However, there is movement afoot to reverse the Myriad decision. There has been criticism of this decision and the Supreme Court's other patent eligibility decisions pretty much from the day that they were released. Not enough patents are being issued, especially in the diagnostics area. And so this has led to a number of legislative proposals, the most recent of which is currently in committee at the Senate, introduced by Senator Tillis, joined, at least in spirit, by Senator Coons, called the Patent Eligibility Restoration Act. It recognizes the genes in the human body are not patentable, and they never were, but those isolated and purified genes would once again become patentable, right? The Supreme Court held in Myriad that even if a gene is isolated and purified, plucked out of the body, if it's the same sequence, it's not patentable. if this legislation is passed, that would all be reversed. It would become patentable again. So what comes next is going to be interesting. We will see. There will be hearings, there will be debate, but this is coming. So, this case, again, just to wind this up, Myriad had a lot of impact well beyond Section 101 of the Patent Act. And, to discover and tell the story, I relied on a lot of people. It's really their story, not my story. And so I offer them a big debt of gratitude for sharing their stories with me. I interviewed almost 100 people for this book and this project, including pretty much everyone that you see here on this slide. And the final thing that I want to say is that, patents are not, these genetic mutations still exist. They appear, and it's devastating news to find out that you have one of these mutations. Force Facing Our Risk of Cancer, Empowered, is a support group for BRCA mutation and variant carriers. They do great work. They were extremely helpful to me in sort of understanding the landscape of this area, introducing me to people. A lot of the photographs in the book were courtesy of them, so I owe them a lot. And as a result, I'm donating half of the, not huge proceeds from this book to them. And if you want to do that, there's a web page where you can make that happen as well. So that's all. I thank you very much for your time and for listening, and for the invitation to come speak with you. And with that, I will end the slide and turn it back over to Jonathan.
Thanks, George. That was fantastic. So I want to open it up for questions from the audience. People can either raise their hand on Zoom or type in into the chat, and we'll try to keep an eye on that. Kara, for the people in your room there, if you want to, if people there want to chime in, if you want to sort of moderate things from that point, I'll just sort of I guess sort of shout out. And I think, unsurprisingly, I see Brooke has a question. Why don't we go? I have a million things, but I've already talked to George about this, so I'll turn it over to Brooke.
Well, I've talked to George a lot too, and had the pleasure of being at a conference with him for 2 days just a month ago. But I want to talk about the, in a way, the real right to health implications of the existing rule, and kind of the newly understood development in diagnostics, and realizing that diagnostics are actually the gateway to treatment. And without diagnostics, clinicians are really struggle to identify what health ailment a person has. And the researchers in the diagnostic space are increasingly turning towards what are called multiplex diagnostics that can, based on symptomology, test for a number of different diseases at the same time, which will help revolutionize the differential diagnosis of the patient's condition and connect them much more quickly to care. And in some instances, for example, for outpatient treatment of COVID-19, you need to be connected to care within 5 days of symptom onset, so that the ability to have a test that works, and even better, a test that has differential diagnosis, is just critically important to future improvements of global health and human health. And so, I guess a question to you, because this was principally, in the legal sphere, this was argued significantly in terms of patent law policy and patent law. In the real world, it was, women's health, right? And now for diagnostics more generally, it's global and human health more broadly. And so I just wonder if what your thinking is about the role of bringing in the real world health consequences of diagnostic testing to the existing congressional debate, to broader public policy understanding of the the issues at stake and playing with these rules.
Yeah, thanks so much, Professor Baker. That great set of questions. And so there are a few things that come to mind. I mean, first, this stuff clearly has to be brought to the discussion, right? You know, sometimes patent lawyers, and I consider myself, in this group, right? Patent lawyers, we think of our field as this highly specialized technical field, like tax law, right? Where not that many people understand it, and like the rules are so detailed. All we care about is like figuring out what the answer is under this highly specialized like rule, the statutory section, and that's how patent cases are usually tried. The really insightful thing about this case was that the ACLU lawyers who lived this case, they're not patent lawyers. In fact, Chris Hansen knew virtually nothing about patent law. He got up to speed and learned it pretty well eventually, but it was an intuitive understanding of what makes sense and what's just in the world that motivated the case. And he knew that, so there was not a jury in this case because the district court was resolved at summary judgment, but there could have been a jury. We knew that jurors and judges were going to think about and respond to these broader sort of public welfare arguments, no matter what the technical patent law decision was, because you could rule, like courts did rule, either way on the patent law question. That's a coin toss, whether or not you're going to say yay or nay under Section 101. What motivates how that coin, which side that coin lands on is the policy arguments, the bigger issues at stake. And you're absolutely right. There were, you've got, in this case, Nobel laureates, filing amicus briefs talking about how science is impeded with all of these patents. You've got, believe it or not, there were biotech companies, the companies who made multi-gene panels and gene chips like Alnylam and GeneDx, who also weighed in on the ACLU side saying, you're not helping biotech, you're hurting the future of the biotech industry. Like, single gene testing is a thing of the past, right? The future is multi-gene panels, and you're crippling that with these patents. All of those issues were not really front and center before the court, but they definitely were important.
So, George, following up on that, if I can just then jump in, a couple of things. Well, I'll just start with one thing then. Is I'm wondering, in all of this, especially towards the end where you're talking about the legislation that's out there, I'm wondering, in this story, does this give you any thoughts about whether or not there should be subject matter specific rules in patent law? The whole thing in patent law is like, oh, everything, there are not specific rules for patenting for different types of subject matter. And do you think, as a way of sort of corralling some of this, whether or not that idea of the sort of uniformity of patent law maybe should be would that be useful at all, and should it happen or not, do you think?
Yeah, that's obviously a provocative question. Thank you for that. Right. So right now, patent law is pretty undifferentiated, right? So as Professor Khan is saying, like, no matter whether the invention is a new screwdriver or a telecommunications satellite or a pharmaceutical product, it's like you treat them the same, right? The standards are the same, the term is the same, for better, for worse. And the United States was very strong in pushing that argument in international treaty negotiations. India did not allow patents on pharmaceutical products until we forced, in the TRIPS agreement, we forced them and everybody else to say, no, whatever the invention is, you can't have these subject matter exclusions. And so now they've got pharmaceutical patents, even though they never wanted them. And so politically, I think it'd be pretty tough for the United States to turn around and now say, well, we kind of changed our mind on that. but politically anything can happen. Congress and the Supreme Court do change their minds, unfortunately or fortunately, depending on where you sit. It would be tough, though. It would be a pretty tough sell. That being said, like, take a look at other areas. Like the Copyright Act is just full of subject matter specific stuff. There are pages and pages of like cable communication and very specific copyright stuff. Pantomime, is like specifically called out in the Copyright Act as choreography, all of these very strange niche cases. So it's doable and we probably should. Yeah, it's a tough political ask.
Sure, thanks. I see a hand up from the classroom. Kara, do you want to chime in from who's ever there, please?
Can you hear me?
Yep.
Good. I have a two-for question, but I think I'm allowed because I'm speaking for at least 20. George, thanks so much. Really, really interesting, especially as I think about how I've been teaching this case since it was filed and teaching it through all the different iterations that it existed. And I started teaching it while I was in Philly. So I had students in the room that had worked with the researchers there at UPenn who were doing testing. And now I'm teaching it in Boston with students in the room that have worked at Myriad Genetics, which I would make nameless unless they want to name themselves. But I have two sets of questions for you. One is cDNA. Every time I see those headlines, your genes have been freed, we won, I keep going, ooh, as a scientist, I'm not sure how true that is. cDNA patents, how much power do they have? How much was actually accomplished in terms of freeing the genome? And then the second question is, if you could talk a little bit more about the political economy of the University of Utah, Myriad, Nexus, and the whole sort of Bayh-Dole ecosystem. I know you moved to Utah while you were working on the book, and now you're sitting right there. So I'd be interested in your thoughts on that as well.
Yeah, great questions. Thanks. So cDNA, the Solicitor General's big compromise here that Justice Thomas embraced wholesale. So in the genetic diagnostics industry that Myriad was in, you need to sequence the whole gene. You need to clone the whole gene and sequence the whole gene because some of the deleterious mutations don't occur in the coding region, right? It doesn't matter if they're in the coding region or not. You need the whole gene. And so it did not help. This exception did not help the diagnostics industry, and they knew that, right? Or I don't know, Justice Thomas, but certainly the people of the Department of Justice understood this. They were concerned about the pharmaceutical industry. So remember, Myriad had composition of matter patents. That covers everything: diagnostics, vaccines, therapeutics, you name it, anything you could do with this gene, whether or not related to breast cancer. Myriad knew it was going to be in the diagnostics business. Eli Lilly wanted the therapeutics business, right? As expensive as Myriad's test was, a $3,000 test. It's an expensive test, but like that's peanuts compared to the cost of a drug. If you know anything about drug pricing, even back in the 90s, everyone knew the real money was in a drug, a chemotherapy agent targeted to the BRCA genes. And that's why Lilly paid Myriad $3 million to get the exclusive rights up front to all therapeutic uses. And so, unfortunately, the BRCA genes that never panned out. They're very unstable genes. There's a lot of issues with them, sort of, biochemically. Never made a drug target out of the genes. If you had, though, Lilly might still have been okay, making some sort of construct that could be used in a therapeutic under the Supreme Court's precedent with the cDNA. We'll never know, but certainly therapeutics that are targeted are being patented still, right? These gene therapies, they are still being patented. On the political economy front, so University of Utah, it was like 100% coincidence. I was at American University in DC when I started this project, when the case was going on. I then moved to Utah and this university for totally unrelated reasons. But it was lucky. In fact, I might never have actually finished this book if I hadn't moved here, because it gave me amazing access to Myriad and the scientists here at the university, and local genetic counselors and people who were all involved in this case. And University of Utah, for historical reasons that you probably all can guess at right there, there's a lot of genetics went on here in the early days, like the golden age of gene hunting. This was a real epicenter of that. Why? Because Utah has huge genealogical resources, all that come from the Mormon church, the LDS church, all made available to the University of Utah. 10 generations of family trees going back, showing how people died, right? And so you can trace these different diseases, different syndromes in families, and then you get the people who are living. They give you a DNA sample, and you can do a lot of genetic epidemiological detective work here. And so, hematochromatosis, long QT, breast cancer, melanoma. There were lots of genes discovered here in Utah for that reason. Also, if you remember back to the 90s, University of Utah was very big in tech transfer and university spinouts. The Jarvik 7 artificial heart was developed here, transplanted into the first human patient here. So the biomedical sort of innovation space was very big here. And then, if you remember, cold fusion, right? Cold fusion, Stanley Pons, who was the head of the chemistry department here, came up with this quote unquote invention that would be the energy source of the future. Turned out did not pan out, to put it gently. Nevertheless, the university raised like millions of dollars from the state legislature and whatnot, really beefed up its tech transfer program in the 90s, all on the back of this cold fusion debacle, which eventually collapsed. Myriad then occupied the building that was built to be like the Institute for Cold Fusion Research as its first facility. There is a huge appetite at this university, to like compete with the MITs and the Caltechs of the world in technology transfer. And for that reason, kind of cast a blind eye toward what was happening here. The University of Utah made something like $40 million off of its royalties from Myriad's breast cancer patent. Some of the patents were owned by the university, right? The university couldn't transfer them, they just licensed them to Myriad. So it's a complicated story, a very interesting story, one that I could go on for much longer about, but there you go. That's a taste of it.
John Lanza?
Thanks, Jonathan. For some reason, I couldn't figure out how to raise my hand the normal way, so I just did it this way.
That is the normal way.
No, it's not. First, thanks. I love the book. I love the idea of the book. I haven't read the book yet, I should say, but I love the idea of the book in terms of tracking a patent and how does it affect society. I guess my question is, do you view this as a success for the system? I mean, if I sort of, from my perspective, it's up to the sovereign to decide who gets the monopoly, right? But going back to England, and the legislature decides what our patent laws are going to be, and they've decided, and they may be changing them with this new bill. And then, at least here in the United States, we have the ability to challenge that through the court system. And the ACLU, I would look at this and say, the ACLU identified a place where the legislature set up the rules in a way that incentivized behavior that was bad for our citizens, and we were able to get some form of redress from that, although maybe not the redress that everybody wanted, but we were at least able to challenge it. So from my perspective, and in full disclosure, I am a patent attorney, but from my perspective, this is actually, I I won't get into whether I think we should be able to patent cDNA or not, but it seems like a success. I don't know if you would agree with that.
Well, yes. So I think it's a success. I mean, I revealed my hand. I think early on, I agree. I also signed onto an amicus brief supporting the ACLU's case. But I think that, I mean, one of the things that I really came away from this case with is just really a sense of faith in the common law system, right? That this is a good system. The Patent Act and the MPEP, right? This is sort of a civil codified thing, but it doesn't answer all of the questions. This was at root a question of statutory interpretation, right? One of the Patent Act says new and useful inventions, right, can be patented. New and useful. So what's new, right? What are those three? What does NEW? What does new mean? That's really what this case was about. It's a matter of statutory interpretation, and you could go either way. The patent office for years had been interpreting it to mean, outside of the body, doesn't occur in nature. That's new, patentable. You didn't have to interpret it that way. Supreme Court interpreted it a different way. And I think the amazing thing about this case is that outsiders, complete outsiders, took a look at what was happening, not knowing anything about what the Patent Act said, and said, this is wrong. We should challenge this. And we have the capability to do it. And, admittedly, the ACLU, it needed the ACLU, right? Laurie Andrews' previous attempt with Canavan's disease didn't work. You need more than a super smart law professor and some devoted clinic students. You need basically a law firm, a machine like the ACLU to do that. And Laurie Andrews, by the way, participated in the suit. She was on the ACLU's team. But you can do it with some amount of legal resource from the outside. You can look at something, you can challenge it, and you can basically change the law. And I think that was kind of inspiring, in my view.
Okay, we've got 2 more student questions from the classroom, and I think that will take us more or less, let's try to get them in before our 2 o'clock time. Kara?
Thank you, Professor Khan. I'm going to ask Jacob Conan and OBM Algonquin each to ask their questions, and then Professor Contreras can maybe answer them collectively. So Jacob, let's see if we can hear you. If not, I'll repeat the question.
Okay. So in the beginning, you said that you could go foraging for a plant and you could purify that, and that alone wouldn't be patentable, but turning it into a cream would be. So I guess wouldn't congressional intervention that would allow for the patentability of a purified sequence that stands alone, wouldn't that in turn create like a rippling effect or a new gold rush for other industries or other monopolies to go into other industries and retroactively patent those purified substances that are not now able to be patented? So I guess, like, is congressional intervention, in your opinion, good in this instance?
And before you answer that, I'm going to get the other question in.
Okay, so my question has been partly answered. So I'm looking at motivation. When I see cases like this, I'm usually bothered about how companies are motivated, because we can't take the part that this was a huge discovery, and then there was so much resources invested into this, regardless of the fact that it was readily available at the University of Utah. But to some extent, I feel like it's a loss to society, because if people or companies are not sufficiently motivated to engage in this kind of discoveries that will really make huge impacts, particularly in our health, what do you think would motivate them? Although you mentioned something about collaboration with the SARS-CoV, well, I can understand that because that was a pandemic. But for instances like this, like cancer and things that are not considered as a pandemic, why would companies want to engage in such research, particularly when it's going to take them a lot of time and resources?
Thank you. So one question about legislation and one about the incentive theory of intellectual property.
Yes. Okay. So I've got 2 minutes for 2 really big but really good questions. So on the legislation question, right? So there is this spectrum, right? When is something like stop being just a product of nature that you found and become a human-made invention, right? I mean, at the end of at a basic level, everything that we ever made is made out of the natural elements, the atomic elements that, were created at the beginning of the universe. So there's some dividing point. One of the examples that got raised a lot during the Myriad case was Taxol, right? A drug made out of the yew tree, basically, or parts of it. And, and it's a chemotherapy agent, I believe. Professor Baker can correct me if I'm wrong on the specific drug. But, there is, so I think that the legislation, I do think that the legislation that's out there right now is not a good idea, even to the extent that it just covers basic discoveries about the world, like basic genetic sequences. Those should not be patented. I'm all for patenting the thing that is improved, right? The thing that humans actually do apply their ingenuity to creating. But the thing that you just find in nature, I don't think should be patented. So and there are lots of examples where I think this legislation will open the door to cordoning off and closing things that ought rightly to be in the public domain. And so that sort of gets to the second question too, which is the incentive question, right? So this is the big one. In the US Constitution, right, the US Constitution establishes the patent system in order to provide an economic incentive for inventions. You don't want people inventing something and then the next day their neighbor's stealing it, making it, and because then there's no incentive for the first person to make the invention. Understood. And I buy that story to some degree. That's not the case, though, with scientific discoveries, or at least basic scientific discoveries like genetic sequences. Number one, most of those discoveries are made with government funding. If Myriad had never existed, it doesn't matter. The other teams racing to find this gene would have found it in another month. I mean, with BRCA2, Myriad filed its patent application literally one day before a research team in London had their results published in Nature. And if Nature had published on a Tuesday instead of a Thursday, then they would have won the race, right? So the incentive doesn't hold up with that gene, but that was a gene everybody wanted to find. What about the more obscure gene, the rare disease? No, you've still got plenty of incentives for researchers to find those genes. Now, the drug to cure that rare disease or the chemotherapy agent, there's plenty of stuff to patent beyond the basic genetic sequence. And think about COVID-19, right? Nobody patented the SARS-CoV-2 viral RNA sequence, yet there's still lots of stuff that got patented around those vaccines. Case in point, there's patent litigation going on all over the place with respect to, the spike protein linkage, the lipid nanoparticles. There's a bunch of stuff that is still patented that's innovative in these products and that people are going to patent, collect money on, and fight over. I don't think you need to patent the basic scientific discoveries, though, to incentivize discovery and research and business.
Well, I think that's a great way to wind things up on that note. George, again, thank you so much for this. And again, I want to recommend to everybody this. It's the most readable book on patent law you will ever find in your life. It's really engaging. I'm waiting for the movie to come out. I'm already trying to cast the characters in my head. And I'm just a real pleasure to have you here. And thank you all, everybody in the audience, for coming and participating.
Yeah, thanks so much for inviting me. Yeah, this was a lot of fun. Thanks.